So you've received a letter of demand or a notice to cease and desist. You may be dealing with a copyright troll, and I'm going to tell you exactly what you need to do. So you've received a notice of copyright infringement, and in this notice of copyright infringement, it is saying that you owe thousands of dollars arising from stealing somebody else's work, monetizing it, and effectively profiting from it. First thing you need to do is not make any admissions. In intellectual property law, whilst admissions are not an indication of culpability, they can affect your damages if they can show that you intentionally stole something from somebody else. So do not make any admissions around that fact. Always deny, 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 and make sure that if you don't have to, don't put anything in writing, especially if you're dealing with the matter without proper representation. The second thing that you need to do is do your own research. Oftentimes they're going to provide you with registration numbers at the United States Patent and Trademark Office or at the United States Copyright Office. And I can't tell you how many times I've actually looked into some of these registrations only to find that either the registration has nothing to do with the work in question, or it's actually an expired registration and the trademark is no longer registered with the United States Patents and Trademarks Office. So it's always important to do your own research because you may find a defense by conducting that research. The next thing is you can always negotiate a settlement. Federal court litigation is extremely expensive and can cost tens of thousands of dollars. Now, I have settled matters against major intellectual property companies like Warner Bros, Hasbro's, Hershey's. I can tell you that even companies with huge and vast amounts of financial resources do not want to spend all of their time engaging in costly litigation. So you can pretty much always negotiate a settlement because most people don't want to go to court, and a settlement will usually work out cheaper for both the complainant and for you as the person who is being sued or potentially being sued as a result of that trademark or copyright infringement. So always come in under what they're asking, but just remember, be reasonable with your counteroffer, but always go for a counteroffer. Then the last and most important thing is always seek legal advice before you engage with an attorney. You never ever want to go into one of these matters unrepresented if you don't have to. Again, the advice that I am providing is for people who are both confident in dealing with a licensed attorney and are willing to take the risk of dealing with a licensed attorney. But if you do not have to, seek legal advice, get legal assistance, and have them take over the matter and take over the negotiations for you. As someone who's settled matters for dozens and dozens of clients against some of the largest intellectual property rights holders in the world, I can assure you that we have the skill and the experience to assist you in the settlement of your matter. So be sure to contact us.